I call the Honourable Member Giles Chevelle.
Thank you, Mr Speaker. Mr Speaker, since the Minister first mooted reform to the legal aid system, the Labor Party has supported, in principle, the need for reform. But it would have to be said that over the course of the debate on this matter, the hearing of evidence in the Select Committee, and with subsequent developments in respect of the government's criminal justice policy, the Labor Party's concerns about the overall effect of this reform, taken with others, is leading to increasing concern, and it is now with quite a degree of reluctance that the opposition agrees to continue to support the legislation at its third reading. I want to run through some of the concerns, the serious concerns that we have increasingly held as the debate has gone forward. The Minister in his third reading speech just made reference to the Baisley report, the report of Dame Margaret Baisley that kicked off this set of reforms. And he said something along the lines that a public servant as experienced as Dame Margaret, somebody as proficient as she is in looking at the best ways in which to deliver public services, should not be lightly ignored. And it's true that Dame Margaret is somebody who has given great service to New Zealand and to its public service. But there are major issues with the Baisley report, and those issues are ones that the House needs to take notice of, because all the reforms that we're debating today proceed from the Baisley report. The most concerning aspect of the Baisley report is the one that was drawn to the attention of the Select Committee by the New Zealand Law Society when this bill was before them, and that is the anecdotal nature of the concerns that Dame Margaret expressed. And she did so in language that I hope she's had cause to reflect on, because she looked in particular at the way in which legal services are delivered in South Auckland, and in particular at the new Manukau court. Now, sir, I've been to that court. I've met practitioners who work there, often on pretty gruelling conditions, sometimes on legal aid assignments, others not. You know, sir, as do other members in the House, that is one of the more difficult courts in the country in which to practice and in which to deliver access to justice to New Zealanders. But there are practitioners who do that day in and day out. They do it unselfishly. They do it often in the face of a system that doesn't seem to care very much about method or outcomes, and yet their professionalism keeps that system going. The greatest matter of regret that I have in this whole debate is that neither Dame Margaret nor the Minister has ever distanced themselves from the more extreme comments that occurred in the Baisley report about those practitioners. There may well be one or two who need better quality control, but the vast majority of those lawyers work very hard to provide access to justice, and it is a crying shame not only that their efforts have not been properly acknowledged by the government, but also that the Minister hasn't chosen to acknowledge that professionalism on a fundamental basis, because without it, that entire system would grind to a halt. And it is also questionable whether an entire set of reforms, such as we're seeing in this House today, can be grounded on the basis of the Baisley report, because of the anecdotal nature of the findings and because of some of the extreme language in that report. And it's important, I think, to put on record those fundamental concerns in this speech. The other concern I think it's fair to put on record that has developed on this side of the House as this bill has proceeded is the way in which it meshes with other matters of criminal justice policy being advanced as part of the Minister's reform agenda. And I think we would need to say that in that category lies not only the restrictions on choice as to advocate that this bill will put into place in the legal aid system in respect of certain categories of offences, but also the three strikes legislation, which I note that the Minister has distanced himself from, but which will have the inevitable effect of increasing traffic, for want of a better way of putting it, through the system. Combine that with restrictions on choice of advocate in the legal aid system, and inevitably you will see a deterioration in the ability of New Zealanders, the people we represent in this House, to access justice. And then there's the package of reforms currently under consideration in the Justice and Electoral Committee, the Criminal Reform Bill, where there is, as the Law Society has pointed out, procedural reform being put ahead of reform of the drivers of crime or the substantive criminal statute, or even really the rules of evidence, an odd way to do it. And in the process we have some restrictions on the right to the presumption of innocence, restrictions on the right to trial by jury, and other major concerns being brought to the attention of the committee, not only by the legal profession but by a number of people concerned with that fundamental right of access to justice. So, Sir, there are some major concerns that we have about this bill. I don't say that all of the bill is bad, and I hope that members on this side of the House have been fair about its provisions as we've gone through the process of debating it. One of the very positive aspects of the legislation is the extent to which it provides some contestability in the provision of publicly funded legal services to those who can't pay their own way. Not only is there to be the continuation of a contracted legal aid provision system for some lawyers, but there's an extension of the public defender system. Now, sir, that's an excellent system. It was introduced under the last government, and it's being extended as a result of the bill that we're debating today. The bill empowers a reasonable extension of that scheme. What needs to be said about the public defender system is two things. One, it provides some choice and contestability in the system. It's a publicly funded, publicly owned entity, the public defender system, but what it does is it provides a defence to people who employ its services. And the evaluations of the public defender service show that the way it provides services is very, very effective and very, very efficient. And that provides good evidence that the state can deliver these sorts of services if those services are structured properly on an appropriate basis. And it can do so in a way that keeps a check on or a reference to the contracted private providers. So that's a good thing. The other good thing is that there'll be a third category of provider. In some places where it's just not possible to find legal aid providers on a contracted basis, then firms will be contracted to provide the service, and we support that. So, sir, in summary, while the reforms aren't all bad, there are some major concerns that we have about them. We've decided we will continue to vote to support the legislation, but it will be very much on the basis of waiting to see what the results are like, and we're certainly not making any commitment to retain the system that would be brought into effect by this bill because of the major concerns that I've listed in this speech. In particular, the concern around the inability of people to make a choice as to their representative or advocate, particularly in respect to some offences where the grant of aid isn't even untrammelled, it's effectively a loan from the state. That is a matter for real concern. And so if it transpires that in the implementation of this legislation, along with the other parts of the government's criminal justice reform agenda, the right to access to justice of New Zealanders is significantly impaired, then the watching brief that we are keeping on it will mean that when we have the next opportunity, we will make significant changes to the bill if they are required.
Speaker.
I call the honourable